Everything I share today is for educational purposes only. This is not legal advice and I am not your attorney. If you have been involved in a self-defense situation or are facing criminal charges related to one, contact a licensed criminal defense attorney in your state immediately. A man breaks into your home at 2 in the morning. You grab whatever you can to protect yourself and your family. The intruder is injured. Police arrive, and within 48 hours, you are the one sitting in a jail cell facing assault charges. How does that happen? You are protecting your home. You are protecting your children. How are you the one being prosecuted? Because self-defense law in America is one of the most misunderstood areas of criminal law in existence. Most people believe that if someone attacks you, you can defend yourself and the law automatically protects you. That is not always true. And that misunderstanding has sent innocent people to prison. Today, I am going to explain exactly when you have the legal right to defend yourself in America, what the law requires, and where people make mistakes that turn a justified act of self-defense into a criminal conviction. The issue. The legal question here is not simply, did you feel threatened? The question the law asks is far more specific. Was the threat reasonable? Was your response proportionate? Did you have a duty to retreat before using force? And where exactly did this happen? The answers to those questions change dramatically depending on which state you are in. America does not have one single self-defense law. Every state has its own version. And the difference between those versions can be the difference between going home and going to prison. The law self-defense is what lawyers call an affirmative defense. That means you are admitting that you took the action, but arguing that the action was legally justified. The burden then shifts to proving that justification. For a self-defense claim to hold up in court, 4 elements generally must be present. First, there must be an imminent threat. The danger must be happening right now or about to happen immediately. You cannot claim self-defense against a threat that happened yesterday or might happen tomorrow. Second, the threat must be reasonable. A reasonable person in your exact situation must have believed the same danger existed. Your personal fear alone is not enough. The standard is objective. What would a reasonable person have believed? Third, your response must be proportionate. You cannot use deadly force to defend yourself against someone who shoves you. The level of force you use must match the level of threat you faced. Bringing a gun to a fistfight, legally, is a problem. Fourth, in some states, you must have attempted to retreat before using force. This is called the duty to retreat. If you could have safely walked away from the situation and chose not to, your self-defense claim weakens significantly in those states. Now here is where it gets critically important. America is divided into 2 major camps on self-defense law. Stand your ground states. There are currently over 30 of them, including Florida, Texas, and Georgia, have eliminated the duty to retreat entirely. If you are somewhere you have a legal right to be and you face a reasonable threat, you can stand your ground and use force without first attempting to retreat. Duty to retreat states, including New York, New Jersey, and Massachusetts, require that before using force, you must attempt to safely retreat if retreat is possible. Only if retreat is impossible or unsafe can you legally use force. And then there is a special category that applies in every single state, the castle doctrine. Your home is your castle. In virtually every state in America, you have no duty to retreat inside your own home. If someone unlawfully enters your home and you face a reasonable threat, you can use force, including deadly force in many states, without any obligation to retreat. Real-world application. 2 scenarios. Same act. 2 completely different legal outcomes. Scenario 1. Kevin is walking to his car in a parking lot. A stranger approaches aggressively, pulls out a knife, and demands his wallet. Kevin is legally carrying a firearm. He draws it, and the attacker is shot. Kevin is in a stand-your-ground state. He was in a place he had every right to be. The threat was immediate and deadly. His response was proportionate to a knife attack. Kevin is not charged. Scenario 2. Same situation. But Kevin is in a duty-to-retreat state. Security camera footage shows that Kevin had a clear path to run to a nearby store. He chose to stand and draw instead. The prosecutor argues he had a safe avenue of retreat and did not take it. Kevin now faces manslaughter charges despite being the victim of an armed robbery attempt. Same person, same threat, same action, 2 different states, 2 completely different legal outcomes. Common mistakes. The first mistake is assuming self-defense automatically protects you. Self-defense is a legal argument, not an automatic shield. You must prove it meets the legal standard in your state. Many people assume that because they felt threatened, they are automatically protected. That assumption has put innocent people in prison. The second mistake is using more force than the situation required. If someone punches you and you respond with a weapon, prosecutors will argue your response was disproportionate to the threat. Your level of force must match the threat level as closely as possible. The third mistake is talking to police immediately after a self-defense incident. You are shaken. You want to explain yourself. You want to cooperate. Do not. Invoke your right to remain silent and ask for an attorney immediately. Statements made in those first emotional moments after an incident are often used against defendants in court. The fourth mistake is not understanding your state's specific law. Stand your ground and duty to retreat are not interchangeable. What is legally justified in Texas may be criminal in New York. If you carry a firearm for self-defense, you must know the exact law in every state you enter. The fifth mistake is failing to document injuries and the scene. If you were attacked and defended yourself, your injuries are evidence. Photograph everything immediately, get medical attention, and make sure it is documented. Witness information, surveillance cameras, physical evidence. All of this supports your self-defense claim. Your action steps on. Right now, today, look up whether your state is a stand-your-ground state or a duty-to-retreat state. This is basic legal knowledge that every American should have before they ever face a dangerous situation. 2. If you carry a firearm or any weapon for self-defense, consult with a criminal defense attorney in your state about the exact legal standards that apply to you. 1 hour with an attorney now can save you from years in prison later. 3. If you are ever involved in a self-defense situation, your first call after ensuring your safety should be to 911. Your second call should be to a criminal defense attorney. Before you speak to any officer about what happened, speak to your attorney. 4. Document everything you can at the scene: photographs, witness names, video footage, locations. Memory fades, evidence disappears. What you capture in those first minutes matters enormously to your defense. 5. If you are charged after a self-defense incident, do not give up. Self-defense cases are won and lost on evidence and legal strategy. An experienced criminal defense attorney who knows your state's self-defense laws is your most important asset. The law gives you the right to protect yourself, your family, and your home. But that right comes with specific legal boundaries that vary by state. Know those boundaries before you ever need them, because in the moment you need them, There is no time to learn. Share this with someone who carries a firearm or lives alone or simply wants to understand their rights. And for any real legal situation, always speak with a licensed attorney in your state.